Good morning. I'd like to welcome everyone to today's argument of the Kansas Court of Appeals as part of the January 2021 docket. Before we get started with the argument on our third case this morning, I'd like to take a couple of minutes and introduce our panel members. First, Judge Anthony Powell has served on the Court of Appeals for the past almost 8 years, since 2013, hails from Wichita, and before joining our court, served on the district court in Wichita for a decade. And then Judge Patrick McEnany from Johnson County served as a judge on the Kansas Court of Appeals for 15 years, retired in 2019, but since that time has been serving as a senior member of our court. And Judge McEnany also served as a district court judge for a number of years before he joined the Kansas Court of Appeals. I'm Sarah Wehner. I'm the newest member of the Court of Appeals, having joined in 2019, and I came from private practice in Lawrence. I'll be keeping time for today's arguments, and at the outset, I would note to counsel that we have read your briefs. We're familiar with the facts of the case, but for the sake of today's argument, I am allotting the appellant an extra 30 seconds or a minute just at the outset of the argument to briefly explain what got us here today. That way, anyone who's observing will have some context for the case. At this point, I'd like to call the third case on this morning's docket. That case is case number 121880. Sarah M. Barron, as representative heir of Barbara J. Barron, and Robert S. Barron, as special administrator of the estate of Barbara J. Barron, versus Treasurer A. Wehner. Parties, would you please state your appearances?
Yes, good morning. May it please the court. Blake Short, representing appellants Sarah Barron and Robert Barron.
And good morning. Brian White appears on behalf of defendant Treasurer Wehner.
Thank you. This case has been scheduled for 15 minutes for both sides of the argument. Mr. Short, would you like to reserve any time for your rebuttal?
Your Honor, may I please reserve 5 minutes?
5 minutes are granted. And with that, Mr. Short, you may proceed.
Thank you. Again, good morning. May it please the court. In terms of an introduction of the case, this is a medical malpractice action, wrongful death, and survival action, which was tried to a jury in Cowley County in March of 2019. And it arises out of care rendered by Dr. Wehner to the decedent Barbara Barron in the early months of 2013, where she was treated for severe respiratory conditions and kidney problems, and ultimately hospitalized and passed away. The appeal relates to a comparative fault claim brought by Dr. Wehner against Barbara Barron, and generally whether there was sufficient evidence to support that claim. Dr. Wehner is a DO and family practice physician who would also cover shifts at the local emergency room there in Winfield, which is William Newton Memorial Hospital. Barbara Barron was a 70-year-old. She was 69 actually at the time of the treatment. Then she would turn 70 before she passed away. A mother and a wife, retired, living in the Winfield area. And the allegations in the medical malpractice case that was tried to the jury over the course of roughly a week were that Dr. Wehner failed to appropriately transfer Barbara Barron to an institution of higher care, a tertiary care center, or a level 1 hospital, based on the complaints that she was providing to Dr. Wehner, both in the emergency room on March the 10th, 2013, and then again 8 days later when Dr. Wehner saw Barbara Barron in the local clinic and her symptoms had become more severe, that she again failed to transfer Mrs. Barron at that time to an institution of higher care. The allegations were, which were established through our two retained experts, that had Mrs. Barron been timely transferred to a tertiary care hospital, she would have received timely and appropriate care from appropriate consultants, such as a pulmonologist or a cardiologist or a nephrologist, and that her severe respiratory and kidney issues would have been solved and she would not have passed away in April of 2013. Those claims, again, were substantiated by our two experts, and we, knowing that it's important to put together all elements of a medical malpractice case, establishing what the standard of care is, establishing that there was a breach of the standard, establishing causation in fact as an element of proximate cause. We're careful to put all of that evidence in through our experts. Conversely, by the time all the evidence was in, the only comparative fault claim remaining for Dr. Wehner was one claim against Barbara Barron. And that claim was that roughly 6 to 8 weeks prior to the treatment at issue, that Mrs. Barron had been seen in the same hospital in Winfield, William Newton, for a similar condition, shortness of breath. And at that time, the allegation was that she had basically gone against the advice of physicians to obtain a CT angiogram to determine if she had a pulmonary embolism, which is also, as it's used in the briefs, PE is used often as short for pulmonary embolism. So the key issue comes down to, and this relates to both of our claims on appeal. Number one, that it was error to allow that comparative fault claim to go forward by denying our motion for judgment as a matter of law. And then secondarily, that the jury verdict was outside the evidence or contrary to the evidence. Both those claims on appeal relate to the ultimate proposition that there was no evidence whatsoever put on during the trial to support that even if Barbara Barron acted unreasonably in not moving forward with that CT scan in January, there was no evidence whatsoever to support that more likely than not, had she have done so, had she have obtained the CT scan, that would have changed the course of treatment and ultimately prevented her death. That's the core issue. We have laid out expert by expert what the testimony was, because as the court recently held in the Puckett case, the Supreme Court case from a few years back, they reestablished that these standard of care issues in medical malpractice actions and the causation issues require expert testimony. There was a jury instruction on that issue as well.
Counsel, wasn't there testimony to the effect that because there was not this test that was done in early January, that pulmonary embolism essentially was rendered untreatable?
There was general testimony that came from, really primarily from Dr. Knox, one of Dr. Wehner's two experts, that, and he made this point several times, that the refusal, as they called it, the refusal for Mrs. Barron to obtain the CT scan was paramount to her course of treatment. But the reason that that claim is sort of illusory, and I can understand how it was persuasive to a jury, is that that proposition was laid out in front of the jury, but it was never explained. It needed to be explained and was never explained if the test would have been negative, as Dr. Wehner's own experts testified to, more likely than not, both of them. Assuming the test would have been negative, what exactly would have been done? How would that have changed the course of treatment? Assuming that led the physicians away from a pulmonary embolism because the test was negative, what alternative treatment would Mrs. Barron have received? What would the standard of care have been? how would that have ultimately prevented her death? There was just this general specter of the failure to obtain the CT scan was a lost opportunity, but it was never explained. And even in the briefing by Dr. Wehner, there's no explanation of causation in fact. What would have been done step by step? If the test was negative, what would have been the next step, and what treatment could have saved Mrs. Barron's life? That's what was missing at the time that we raised the motion for judgment as a matter of law. That's what was missing, as we pointed out on our motion for a new trial. And that's what still has never been explained, is there's an effort to backtrack and talk about that those events in January were important, according to the defense, but there's never been any evidence, like the evidence that we put on to support our claims, as to if that CT needed to be done, how would that have dictated the course of treatment? To get more specific, our two experts both laid out all of that testimony. There was Dr. Schufeld, who was an emergency physician, who testified that he did believe more likely than not that Mrs. Barron ultimately did have a pulmonary embolism in March during the treatment at issue, and that it was negligent or below the standard of care not to refer Mrs. Barron to a tertiary care center for workup of a pulmonary embolism, and he explained what treatment would have been done to save her life. Dr. Salzman was our pulmonologist, who testified that it was possible that Mrs. Barron had a pulmonary embolism in March, but more likely that she had a pulmonary condition. However, he similarly explained what treatment would have been done to save her life, assuming that was the condition. Either way, both doctors agreed Mrs. Barron needed transfer, and the transfer would have led to life-saving treatment. So then the defense and Dr. Wehner had to strategize about how they wanted to defend the plaintiff's claims and what expert evidence they wanted to put on. And they elected to go with a different cause of death. Their cardiologist, Dr. Grabeau, testified that Mrs. Barron did not have a pulmonary embolism. He testified that she had diastolic congestive heart failure and then ultimately passed away due to a lung injury from being on mechanical ventilation. So he went totally away from pulmonary embolism as a cause of death and affirmatively testified during cross-examination that more likely than not, a January 2013 CT scan would have been negative for pulmonary embolism. Then Dr. Knox, the family physician, who I think also does some emergency room work, testified that the January CT scan was important, but ultimately agreed with Dr. Grabeau that that test would have been negative, and never explained what life-saving treatment would have been provided to Mrs. Barron after that negative CT scan came in. So that was the defensive strategy, was to go away from the cause of death that the plaintiff put on through experts. Both experts affirmatively testified that that CT scan that Mrs. Barron did not have would have been negative, and never outlined any causation testimony as to what would have happened specifically after that test. We raised the issue during a fairly long exchange with the court following the close of the defense's case, when we moved for judgment as a matter of law on this one comparative fault claim. And the arguments were similar, made by Dr. Wehner, that are being made now, and that were that you can sort of piece together everything from March and work backwards and go back to January, and you sort of have to look at the series of treatment over those 2 months to determine ultimately that that test would have had some impact on her care.
Counsel, I want to interrupt you for just a second because you reserved 5 minutes for rebuttal, and I just wanted to let you know that you're coming to the end of your 10 minutes. Now, if you'd like to keep on going for a little while, you can do that, and that'll just take into your rebuttal time. Or if you'd like to kind of wrap things up at this point, that's fine as well.
Thank you, Your Honor. I'll just wrap things up by saying that the court generally referred to this continuum of events that Dr. Wehner's also discussed in the briefing, and that's not enough. It doesn't explain causation, in fact, to the extent required for that claim to have been put to the jury. With that, I'll reserve my remaining time again. Thank you.
Thank you.
Counsel, before you get away, let me ask you a couple of questions, if I may.
Yes, Your Honor.
On I think it was January 18th was when your client refused the CT angiogram to rule out pulmonary embolism. It's my understanding that the reason she refused to go forward was because they were having a hard time poking her vein in order to put the what do they call, the contrast material in. Is that correct?
That is correct, Your Honor. We didn't want to. We wanted to focus on the causation issue, but we generally disputed the proposition that she refused that CT scan.
Well, that's what I'm trying to understand. At that point, she had, at least from what I've seen in the record, she had not been diagnosed with a raised creatinine level, had she?
No, at that time, her kidney function would have been sufficient to get the contrast dye.
Right. Well, I guess what I'm trying to understand is the claim of comparative fault is based upon her not following through and following the doctor's recommendation on that particular date to get the CT angiogram. Is that correct?
Yes, Your Honor.
And it was really 2 months later when, in fact, 2 months to the day, when the defendant wanted to do a CT angiogram, but her creatinine level was too high, so that foreclosed that opportunity. Is that correct?
That was correct, that by March the 10th, the creatinine was too high. And so on March the 10th and March the 18th, while a VQ scan would have been available, the CT was not.
So, I mean, looking back, it looks like it was a mistake for her to decline to go forward on January 18th. But did anyone know, or did anyone tell her, lady, this is your last chance, because when your creatinine level arises, or it's likely to rise, and that's going to forego this test, and we'll never be able to check this out. Was she ever told that?
No, Your Honor. There was no evidence of that at all. After the
I'm trying to understand on the issue of foreseeability, how do we get a breach of how do we get negligence out of this? But
I agree. The only thing that happened was they discharged her. She said, my doctor only sent me here for a breathing treatment, and you guys aren't getting the needle for the contrast dye. I'll go back and see him again. And she did, and she didn't go back to the hospital for almost 2 months.
All right. All right, that's all I have. Thank you.
Thank you.
Any other questions from the panel? All right. Thank you, Mr. Stewart. You have 5 minutes for rebuttal still.
Thank you.
Mr. White?
Morning, Your Honor, and may it please the court and counsel. I'm Mr. White, Brian White. I appear today on behalf of my client, who was Dr. Treasurer Wehner. As plaintiff's counsel pointed out, Dr. Wehner is and has been a family practice physician in Winfield, Cali County for many years. Not unusually so, when you're in a smaller community, you also, as a family practice physician, cover the ER, and it's within the context of both her practice as a family practice physician and as an ER provider that Dr. Wehner was sued in this case. The only issue before this court is whether there was sufficient evidence to support a comparative fault defense that we raised on behalf of Dr. Wehner. And the issue is actually even more narrow to Your Honor's question about negligence, because plaintiff's counsel has not raised an issue today that there wasn't sufficient evidence of negligence. And so for today's purposes and for appeals purposes, the court must accept that there was sufficient evidence of negligence, and the only real issue was there sufficient evidence tying that negligence to her injury or death? And it's that very narrow issue that we're here before the court today. It's also important to understand that the standard review for this court is that all evidence and inferences from that evidence must be reviewed in the light most favorable to my client. And it's not this court's job to reweigh the evidence, but simply to see if there was sufficient evidence to support the defense. We had a jury of 12 members of Cali County that listened to the evidence live, weighed that evidence, and ultimately came to the conclusion that it did in this case, which was that Mrs. Barron was 60% at fault in her injuries and death. I will,
Mr. White,
yes.
Before you jump into your argument, could you provide the facts in the record that from which a jury could find that causation in fact in this case on the part of the plaintiff or the decedent?
Sure, Judge. I think there's a multitude of facts that are supportive of it. And let me talk about 5 basic facts that are supported by the evidence. Number one, the evidence supported a finding by the jury that this condition, whatever the condition was, started as early as January 18th, 2013. That's the first time Ms. Barron goes into the emergency room with this condition. And that's the day that she refuses this test, this very important test, the one test that would have given the doctors the opportunity to rule in or rule out a pulmonary embolism. Another important fact is that based on the testimony of the experts, there was evidence that Mrs. Barron would have survived had she received treatment prior to March 20th, 2013. And that was primarily supported by plaintiff's expert. The other important fact, one of the other important facts is that a CTA or a CT angiogram is really the gold standard for ruling in or ruling out a pulmonary embolism. And that was supported by, I believe, all 4 experts that testified in this case. Importantly, Barbara Barron was told on January 18th that she needed a pulmonary CTA, that a pulmonary embolism needed to be evaluated, and she refused that test. And the evidence shows that that was the last time, at least the last time, obviously we don't know every day because she didn't have lab work every day, but based on the lab work that was completed thereafter, that was the last time she was medically eligible for that test. And then I think, and all of those facts are supported by the evidence that we cited into our brief, and I can go into them in a little more detail, but I think you also then need to look at what plaintiff's theory of the case was to understand our comparative fault defense. And to that end, it's also important to understand, we told the jury, number one, nobody was at fault. That's what you should find. But alternatively, if you believe plaintiff's theory that Mrs. Barron needed more timely treatment and that the failure to give timely treatment caused her death, then you have to also consider Mrs. Barron's role in that process, because she had an opportunity to have a test and she refused it at a time this condition was ongoing. But when you look again at plaintiff's theory, it is really, and we try to point this out in the brief, and I want to make it crystal clear today, plaintiff's counsel argues, well, defense counsel's position is very vague, but I would submit to this court that plaintiff's counsel's position and the argument to the jury was very vague and superficial as well. It was a broad idea that bigger is better. Well, she had a complex condition, so she needed a higher level of care. Bigger is better. Why? Because they might have more specialists. Okay, but what's that mean? And I think if you dig into the record, you'll find that they had a hard time really explaining it other than to say bigger is better. But that's not good enough because Mrs. Barron was ultimately transferred on March 20th. So you can't just say bigger is better. you have to have more. And so they say, well, not only is bigger is better, but it had to be done sooner, had to be done quicker, had to be done before March 20th, because that's when she was ultimately transferred. So when you combine all those and you look at the case, what really becomes important? What's going on? What's causing her underlying condition? And that's where the real confusion comes into play. The real confusion, or at least the potential for confusion from plaintiff's theory, is multifaceted. One, we have a period of January to March where Mrs. Barron is seen by no less than 6 doctors. Yet Dr. Barron is the only one sued for not agreeing to transfer my client or Mrs. Barron sooner. We can't figure out what the underlying condition is because there was no autopsy done upon death, and Mrs. Barron had refused to test the definitive test to rule in or rule out one of the potentially strong arguments of what was causing her condition, a pulmonary embolism. The truth is, you can look throughout the record from the beginning until her death in April. No one ever diagnosed her with a pulmonary embolism because no one could ever definitively rule it in or out. And so here we have no real definitive cause of death. And then we take it a step farther. Plaintiff presents 2 experts to talk about cause, and they come to different conclusions. One says it's a pulmonary embolism. The other one says, well, I can't say that. I think it's some kind of respiratory condition. And then you add on top of that, plaintiff's counsel's argument to the jury that I think further confused what the heck was going on with Mrs. Barron at that time. But ultimately it was bigger is better, and more timely treatment would have avoided her death. And it was within that realm that we believed it opened the door for us to say, well, if bigger is better and she would have survived with more timely treatment, then you have to consider the fact that Mrs. Barron, at a time she was eligible, refused a test that would have assisted all subsequent providers in evaluating what was going on and then being able to make decisions, judgments, medical judgments, to decide what to do with Mrs. Barron. I laid it out in my brief. I called them theories, I guess, because I didn't know for sure what to call them. But really what it is 3 ways that the jury could have reached the conclusion they did in their case. And I would submit to the court that obviously I wasn't a member of the jury and you can only get into the jury's mind so much. And it's not really our job today to do that. But what I tried to do is lay out how could we have gotten to where we got? How could we have gotten to the 60% fault that the jury ultimately found, and that the district court, the trial court, heard the evidence and said that there was sufficient evidence to support. And the first way that I argued in my brief, and I'll argue today, is the jury could have reached a conclusion that she had a pulmonary embolism on January 18th. And how could they have reached that conclusion? Based on plaintiff's own experts. You have Dr. Salzman, who I believe plaintiff called second, who testified under oath that the condition started in January of 2013. You had evidence from Dr. Schufelt, the second expert, that a pulmonary embolism is a progressive condition. It starts, and then it gets worse, and it gets worse, and it gets worse. Again, we start in January, we get to March 20th, where she ultimately gets transferred. And to this point, I want to make sure that we're abundantly clear. There was not a lot in the record about her condition from January to March 5th when she comes back to the ER. And certainly plaintiff was left to argue based on the evidence that that was a huge gap, that you can't really tie it all together. And I think plaintiffs attempted to make that argument. The jury heard it, the jury heard our position, and the jury ultimately agreed with our position. And so, again, looking at the evidence in the light most favorable to Dr. Wehner, you can say, well, that gap may or may not have been important, but the jury ultimately found that it wasn't as important as the fact that she refused the CT. And here's plaintiff's counsel will argue, I'm guessing on rebuttal, no one ever said that Mrs. Barron had a pulmonary embolism on January 18, 2013. But we can't take away from the jury logic and common sense. The jury still is allowed to hear the opinions of an expert and tie those to the facts of the case. And what Dr. Schufelt testified very clearly is on March 10th, when Mrs. Barron comes into the emergency room, her condition, he agreed he didn't have a CT scan to rule in or rule out pulmonary embolism, and no autopsy to support the fact that there was a pulmonary embolism. But he said, I believe she had a pulmonary embolism on March 10th, 2013. Why? Because of her presenting conditions. And what are those presenting conditions? Mrs. Barron was obese. She had shortness of breath. She had an elevated D-dimer test, which I would attempt to explain, but I can't because I'm not a doctor, but I understand that that's a sign of potential pulmonary embolism. She had swollen extremities, swollen lower extremities. She also had a normal chest x-ray and clear lungs. And Dr. Schufelt says, that screams, I have a pulmonary embolism. Something needed to be done. Okay, Dr. Schufelt, what was her condition on January 18, 2013? Same, obese, shortness of breath, elevated D-dimer, swollen legs, clear x-ray, clear lungs. Does that scream pulmonary embolism? Yes. All right. What more do I need to establish that she had a pulmonary embolism on January 13, 2018? I respectfully submit I don't need anything else, except I'll take it a step further. Dr. Schufelt went as far to say, I'm actually also critical of the ER provider on January 18, 2013, because he didn't take action to get additional treatment for this patient because she was screaming, I have a pulmonary embolism. And so I think when you look at all of that evidence in light of plaintiff's causation theory, which is Mrs. Barron died because she did not receive timely treatment, you go all the way back to January 18th and say, the evidence supported she had a pulmonary embolism then, as Dr. Schufelt argued in March, and she refused the one test that would have assisted to rule it in or rule it out. That's causation in fact, that's causation 101. And I believe that based on a theory that she had a pulmonary embolism in January that progressed until her ultimate death, and her refusal to take the one test that would have ruled it in or out, her cause needed to be considered. And the second theory that I will quickly address, because my time is running short, is that we presented Dr. Gerbeau to opine that it wasn't a pulmonary embolism, it was a heart condition. And when you take that evidence in connection with the idea or the fact that subsequent providers were working off the fact that it was a pulmonary embolism and they were denied the opportunity to have this test because of Mrs. Barron's decision, again, it kind of, you follow the same logical path, and that's another way that the jury could have reached it. But I really want to address as quickly as I can the last one that I raised in my brief, which is this court doesn't have to get tied up on, did she have a pulmonary embolism? What would the CT scan have shown? Because we presented Dr. Knox, who said, it doesn't matter what it would have shown. This test was the one opportunity for the healthcare providers to rule this condition in or rule it out. And it was a paramount test, and all subsequent providers were denied that information that would have helped them in reaching a diagnostic conclusion in this case. That was his testimony. If you read it in whole, he was pushed on it. He said it was a very important test. It needed to be had. What would it have shown? It doesn't matter. Why doesn't it matter? If it was positive, she has a pulmonary embolism. They treat it then. My client's probably never involved in the case. If it's negative, that's an additional piece of evidence that all subsequent providers would have had that they didn't get because of that refusal. And again, when you tie that all back in to what plaintiff's causation theory is, which as a defendant putting forward a comparative fault claim, we're allowed to rely on plaintiff's causation theory, which is bigger is better, more timely, would have saved your life. Yet she denied us an opportunity on behalf of Dr. Wehner, denied her an opportunity to have an important test. And I think that was sufficient under all of the evidence when you read it as a whole to support that there was sufficient causation tying that failure to her injuries and death. And for that reason, Your Honors, we would ask that this court affirm the jury's finding a fault of 60% upon Mrs. Barron, and also affirm the trial court's ruling both on the motion for judgment as a matter of law and the motion for new trial. And I thank you for your time today, unless there are additional questions.
Thank you. Are there any other questions from the panel for Mr. White? Thank you, Mr. White.
Thank you.
Mr. Stewart, you have reserved 5 minutes for rebuttal. You may begin.
Thank you, Your Honor. Again, may it please the court. Judge Wehner, you laid out the absolute core issue on this appeal and asked Mr. White to lay out the facts supporting this claim. And once again, all that was provided were a series of facts that sound good but don't answer the question. Specifically, Mr. White said, number one, there was evidence the condition started as early as January. There was testimony from Dr. Schufelt that there were similar symptoms in January. But again, both of the experts presented by Dr. Wehner said the test would have been negative for that condition in January. Second fact was that in March, Mrs. Barron had the opportunity to survive, that she could have been saved as of March if she had received timely and appropriate treatment. That doesn't answer the question. Just because you can go back in time and say she would have also survived in January, that doesn't answer the question of, as the jury instruction on causation states, how was the party's conduct the cause of the event? Or how would the event have not occurred but for her conduct in not having the CT scan? So that second fact doesn't answer that question. The third fact stated by Mr. White, the CT angiogram is the gold standard. That doesn't answer the question. That the CT scan is a good test. That both of his experts said would have been negative for this condition. And lastly, the fourth fact, I think Mr. White said there were 5, but I counted 4. The fourth one was, this was the last time Mrs. Barron was eligible for the test. That doesn't answer the question either. And then you dovetail into Dr. Knox, who again offered this testimony that would sound good to a jury if a doctor is stating over and over again, this patient should have had this test done. This patient should have had this test done. So maybe that covers the question of, was Mrs. Barron unreasonable? But it doesn't answer the question of, how would that have changed things? How would this event not have occurred? And again, there was no evidence when Mr. White discussed Dr. Knox's testimony. All he could say was it would have been a, quote, additional piece of evidence for the doctors. How does that explain? How would Mrs. Barron's death been avoided if she had had the CT scan? Again, that doesn't answer the question. There was this suggestion from Mr. White that maybe the claims were somewhat vague in terms of the comparative fault, but that our claims were as well. And I would dispute that being the truth based on the record. Understanding that causation, in fact, is a crucial element of a medical malpractice action, and that we would have been on the defending side of a motion for judgment as a matter of law if we did not lay out our case. The record reflects that each expert explained at March 10 and March 18, 2013, for both dates, why the standard of care required a referral, what would have happened during that referral, what specialists Mrs. Barron would have seen, what those specialists do, what type of tests they order, and ultimately that those referrals would more likely than not have saved her life. That is not laid out in the defense's comparative fault claim, which is why we are here, requesting that the court's order denying our motion for a new trial be overruled and that the court be remanded back to the district court for a new trial on all issues. I wanted to leave a little bit of time to answer any final questions that the court might have.
Any questions from the panel for Mr. Stewart? No questions from the panel. Mr. Stewart, you do have another 30 seconds if you want to wrap up, or if you feel like you've done that, then that's fine.
Okay, I will just raise the last point about prejudice, and that is that this jury found Dr. Wehner was at fault. They found that she was 40% at fault. And they also found, based on this one single claim of comparative fault, that Mrs. Barron was 60% at fault. And of course, if that comparative fault claim had not been interjected into the case, they had already found Dr. Wehner at fault. So the record suggests that Mrs. Barron would have won the case and Dr. Wehner would have been found 100% at fault. So this was a crucial issue. It dictated the outcome of the trial. And again, based on that, we're respectfully requesting that the court overrule the district court and remand this case for a new trial. Thank you very much.
Thank you, counsel. The court will take this matter under advisement and get a written opinion out just as soon as we can. But I want to thank both attorneys for all of the time that you've spent putting into this case. We obviously appreciate your work and your candor to the court today. So at this point,